Hello, I hope you all can hear me. Let me introduce myself. I am William Gamble. I'm a consultant for ITG, and today we're going to talk about what organizations need to know about basically where the law is. I know it says, do I need to comply with GDPR? And the answer to that question is, it depends on where you are, what you do right now, but in the future, the answer is definitely yes, because the GDPR, or at least versions of it, have changed across the world. So, sorry about that. Anyway, this is what we do for IT governments. We're a one-stop shop for all your cybersecurity needs. Anyway, so let's go on the agenda right now. Let's start with, does my organization need to comply? Well, comply with what is what we're going to go into. The real problem with the GDPR is that although it did come into force last May 25th, and that is for all of you people who actually do business in Europe or you sell into Europe. What has happened over the last couple of months, probably for economic reasons, and actually over the last couple of years, is 15 different countries in Asia, including Brazil and now India, Qatar, Kenya, Bahrain, South Korea, Vietnam, Thailand, Malaysia, Australia, Japan, all have changed their laws to basically come into accord, if not identical to the GDPR. So what's happened is that the GDPR, for reasons in terms of transparency and transfers, has become the global norm. So the question is if you are doing business in the world. Now, let's say, okay, well, I don't care about that. I just do business in the United States. Well, it doesn't get you out, because the problem is business in the United States, all 50 states have breach notification laws, and now as of June 28th, we have the California Consumer Protection Act, which is, and there are a bunch of questions in Congress about privacy laws. Let me also make a distinction here. Throughout the world, there are really three types of laws that sort of come under cybersecurity. You have straight cybersecurity laws, and cybersecurity laws, a good example of that is the New York Department of Financial Services law, and that basically says, thou shalt institute cybersecurity, and this is what you have to do it. And they, you go down the checklist, and there's that and the other thing. Okay, that is absolutely required. That's a cybersecurity law. And then there are other cyber privacy laws. Now, those laws deal specifically with privacy. That basically says, what it really does is it defines the property rights of the data. And that says, well, how can I use your data? And the final type of law is the breach reporting type of law. And that doesn't have anything to do with cybersecurity, although it might. It doesn't have to do with privacy, although it might. All it says is that if you tell somebody about something, so those are the three types of laws. Now, the GDPR is an example of a cyber security law and a privacy law. An example of that in the United States would be like HIPAA. HIPAA is a cybersecurity law and a privacy law. And then, so they're all different types. Each one of them to figure what one applies to you. Now, the main issue why we're seeing, and this is, I've been studying international laws, and I've written 3 books. I also have 4 certifications in IT over the years in international law, and I have never seen a law become the international norm so quickly. Normally, it takes 20 years. And the big reason for this is the data transfer rules. The data transfer rules say thou shalt not transfer data out of the EU area unless it goes to a country that has adequacy. In other words, a law that protects privacy. So if, let's say you're a trading country like South Korea, and there are 3 major markets in the world. There's Asia, North America, and Europe. And 2 of them basically say, well, we don't care. And one of them says, well, if you want to trade with us, this is what you have to do. So the trading countries, mostly in Asia, says, damn, we've got to make sure our laws comply with this new requirement. And so they all turn around and within a few months have passed this new type of law. So this especially applies to Brazil, whose major trading partner is the EU. And Japan is now on road adequacy, and South Korea will as well. Now, the United States, I might point out, is a little behind the curve on this one. In the good old days, remember the GDPR isn't new. It's actually it's a old act that was passed in 1998, and the main difference are the fines. That's why everybody's paying attention. Anyway, so they had a law that said, okay, we can transfer data under the old safe harbor rule. And that was thrown out by the European courts in 2015, and they came up with something called the Privacy Shield. And I'm actually personally surprised that Privacy Shield still exists. It may not exist in 2 weeks. So it's really nothing to even bother about right now, frankly. Because even if whatever it says, it doesn't say, it's not going to apply to global compliance. And just, dealing with privacy and basically a law that basically has no relevance anymore is sort of stupid. Will the GDPR, will the EU data protection regulation help the US law? The answer is yes, and then we'll go to the differences between the US state and global compliance. I think I went to, there we go. Okay, organization. Okay, the question is whether the GDPR. The GDPR jurisdictional requirements are you established in the EU? And that's pretty simple type of jurisdiction. In other words, if you kill somebody in France, you're going to be tried in French law. If you have a EU, you will have to comply with EU stuff. If you have a subsidiary in the EU, the other way is that you are either monitoring people's behavior in Europe, you like their GDPS, whatever, you're monitoring their location, or you're offering goods or services. Well, how do I offer goods and services? My example is a hotel in Kissimmee. If its website is all in English and only takes tons and dollars, then it's not offering anything to the EU. If its website is in German and it takes deposits in euros, then obviously it is offering services to data subjects in the EU and is subject to the jurisdiction. Now, again, the GDPR, if it even wasn't adopted by many of these other countries, the other countries were certainly influenced by it. So the easy one, obviously, for all these other countries is that if you have an office in Brazil, India, the whole list, you will be subject to their laws, obviously. The other point is offering goods or services. That varies according to the law, but many are very close. I think Taiwan is that if it doesn't matter, if you're doing something to a Taiwanese citizen anywhere, then you're subject to their particular law. So that's the jurisdiction. Okay, now here are all, this is by the way a partial list. And by the way, this is changing radically all the time. So I'm working on a list, I'm down to Malaysia, I believe, of all these various types of things. These are the various jurisdictional requirements. Like for example, if you're targeting in South Korea, in Brazil, you have to be established or collecting information on Brazilians, and it varies according. The California Consumer Privacy Act is that if you're a company with offering goods or services to California residents, and who isn't, since they make up, since California economy is 12% of the U.S. economy, and if you're 25 million in revenue, or you hold data on 50,000 Californians, then you're subject to that act. That act is not in effect yet. It will go into effect until January 1st, 2020, and I'm sure that right now people in Google and people like that are fighting tooth and nail to restrict it, but I don't think they'll be able to do so for long because because Google itself as a result of not reporting the breach is probably also now in deep poopy. So they have their own problems. Okay, the California Consumer Privacy Act. This is a law that had some rather interesting origins. What happened was there's a real estate developer, I forget his McAllister or something like that. Anyway, he was talking to a Google engineer, and he said, "Mr. Engineer, how much information does Google collect on me?" And the engineer unfortunately said more than you'd ever want to know. Anyway, that's the story behind that. I'm not sure if it's totally true, but anyway, this real estate mogul decided, we got to do something about that. So he started a ballot initiative. All right, this was not something the legislature came up with by itself, or probably even wanted to come up with. It was just existed. So he started a ballot initiative and went out and got signatures. He needed 300,000 names, and he got 650,000. So it came in like a steamroller. Anyway, the legislature freaked, and they said, "Look, let's make a deal. We will pass a law," which obviously, if they pass it, they can amend it. The legislators did this. "If you agree to take it off the ballot." And so, and the organizers said, "Okay, we agree to take it out if you pass the law by June 28th, which is the deadline for taking it off." Anyway, gosh and golly gee, didn't the legislators just pass it by the 28th? So it is, right now, it is a law in Florida, California, and it is due to go into effect as of 2020. Of course, the difference is there are some, they have amended it slightly in the last couple of months. I don't think they'll be able to get rid of it, simply because I think that the political momentum behind it is so intense that they will probably go into effect. The problem is it has had impact on everybody else, including the federal, which is federal things. So even the Republicans in the Senate are considering a similar law. Okay, what's required? Well, you do have to understand data flows, because you need to know whether or not you're offering services to people in California. You have to maintain reasonable security. Okay, that's a tricky line right there. Maintain reasonable security. Watch out for that line, because that little puppy dog pops up in just about all the laws I've read. Reasonable security. Now the problem is that with reasonable security is we don't really know what that is. I mean, does reasonable security mean certification, or does reasonable security mean checking your firewall logs occasionally? So I guess that's a real problem, because that might have to be defined by the courts. But the California law is far more aimed very precisely. The GDPR, for example, and all the other laws in most of the other countries affect everybody. All right. It doesn't matter whether you're a government agency. It doesn't matter whether you're a nonprofit. It doesn't matter whether you're an international corporation or an individual. You're under that law. The law is the same for everybody. And it goes broad. It defines very specifically what a data subject's right in their property is. Now, we got rights, and our data is a property right? Yes, it is. Actually, that has been around in the United States, has been around for about 100 years. And so, yes, you have the right to restrict what other people know about you, what they can do about that. Now, it wasn't a big one until we got into social media and stuff like that, and tracking, and of course now it's become huge. And the California Act was designed specifically to deal with this concept. And basically they deal with it in two ways. They basically say, okay, you have the right to see what companies have on you. You have a right to make sure that they stop spying on you or collecting any information. And you have the right to delete all the information on you. There are other rights. I mean, it isn't all these statutes run on for 20 or more pages. So you have to be very careful with all of them. And they're all a little different. But the main point is that if you comply with certain things in these things, you can have the probability of complying with about 90% of the stuff in other laws. For example, the GDPR, the California Protection Act, requires you to have a big red button on your website. It says, "Do not track, don't touch me, get away." That's not that's not actually required under the GDPR, but it's not, you know, it's not actually that hard to not erase. Like allowing people to know what information you're collecting on them is very similar. Under the GDPR, it's called a subject access request, and under the California Act, it's just the right to know how much information you have. The right of erasure is in the GDPR, but it's not as strict as it is in the California Act. In order to figure these things out, what you have to do is, the first thing you've got to do is find out what data you have, which is always a good start. That's where you start. You start with cybersecurity starts with inventories. It doesn't start with super duper, in my view, as an advanced security practitioner. It doesn't start with your wing wang, you know, firewall. It starts with an inventory. What information do you have? What assets do you have? Okay, and then the next question is, what do you do with them? So that is basic for all these types of laws. Now we're going to talk briefly about the role of an EU representative. Now, in the United States, if you do business in the United States, and you do business outside of your state, which you really can't help not doing, you will need what's called a agent for service of process. So let's say I'm in Rhode Island, and where I live, and I want to sue Amazon, which is out in Washington. Well, I don't have to file my lawsuit in the courts of the state of Washington. I can go up to the local court, you know, right here in Newport, and file a case, and I would serve my pleadings, my statement that I'm suing you, on Amazon's local agent for service of process, and they would collect that and send it to the Amazon legal department, or hopefully they'd forget about it, and then I'd be able to collect my judgment. Anyway, a representative is something in the EU which is exceptionally similar. If you are subject to the GDPR, in other words, if you have an office in the EU or you're offering goods or services to people in the EU, you need to have a representative, which is basically a local point in contact. It allows for any person in the EU who's aggrieved with your operations, or the regulators who are aggrieved with your operations, to contact you. So what they do is it's just a local representative, and that can be anybody, can be your own employee, or you can contract that out. For example, our firm does that. We represent tons of organizations that don't want to pay for it, but they need to have somebody this. These people are not responsible for anything. They're almost sort of like a mailbox, if you will. Anyway, so, and then there is another creature here. It's the data protection officer. These are sort of rare birds. They only exist, so they don't exist in the California Act. They do exist for the in a way for the New York Department of Financial Regulation. The NYDFS regulations require a CISO, or the Chief Information Security Officer. A data protection officer only exists if you are a state agency in Europe, if you are dealing with what they call Category 9 information, which is hot information, or information that would make people uncomfortable, like sexual orientation, healthcare, religious beliefs, racial, ethnic origins, stuff like that. Don't call that sensitive information, because the word is defined in probably all the different state laws and most of the international laws, and it varies from place to place. For example, in India, they feel that sensitive information is caste. So if you are a Brahmin or a Dalit, that is a sensitive information. And in the United States or in Europe, they don't care about that. They do care about, in Europe, they care about whether you're union membership. So if your organization deals with that type of information, you need a data protection officer. Finally, if your organization surveils people in public places, you need a data protection officer, and the data protection officer has certain jobs. There's sort of like a very, very independent employee of the organization who's there to make sure you comply with the regulator, and they have enormous independence, which unlike certain people in the organization should be independent, like your internal auditor should be independent, and your house counsel should be independent. They're usually not, because their jobs are not protected in law. In the GDPR, this person is protected by law. Anyway, it's sort of a rare beast. It does exist in Europe. It exists as a CISO in the New York Department of Financial Services Law. It does not, and exists in India as far as I know. I don't think it found its way in Brazilian law, and it probably might exist in Qatar if you go that route. Okay, the U.S. Privacy Shield, is the U.S. Privacy Shield enough cover? The quick and dirty answer to that is no. Forget it. This was a really bad idea. The EU Parliament, the EU government, the European Union government is similar to the United States in that they have separation of power. But certain power was ceded to the larger organization by the EU states, but some is not. Anyway, the EU Parliament, which is their legislative branch, said, forget it, dump this puppy. Now, the executive branch, which is the EU Commission, so far has said, we're not going to do it. That's what they did last year. The US is fine. However, right now it's under consideration, and whether it will survive, I don't know. Anyway, so we've got the legislative branch attacking it, and 5 hours after the GDPR went into effect, there were lawsuits to get this thing thrown out. They are making their way up to the the EU CJ, European Court of Justice, which is the Supreme Court of the EU, and they're working their way up in that level. So whether or not they actually get up there, when they get, it's not really a question of what happens when it gets there. It's just a question of when it gets there. So the Privacy Shield, there are about 3,000 companies that have self-certified under the Privacy Shield. But the problem with the Privacy Shield is, so what? I mean, the Privacy Shield only exists, let's say, even if it does get reactivated, and it does exist for another year. The problem is it is so far out of whack with global regulatory requirements that it's just sort of bad news, because even if you comply with the Privacy Shield and you can transfer information to Europe, you may not be able to transfer information to a whole lot of other countries. So it's better to try to make sure that you utilize some of the other exceptions to the rule, and there are a total of 5 of them, rather than messing with the Privacy Shield. I think that's personally an absolute total waste of time. Is my bet, but it for now it does exist, but I wouldn't basically bother with it. Okay. Now here's more Privacy Shield stuff. Again, here's an example of these various other countries. They have different requirements. The big one is called adequacy. The adequacy is whether or not the trading company, the country that you're transferring information to, protects the information with laws similar to that of the GDPR, or if you're in Japan or South Korea or Brazil, whether or not the other country protects the law. That's called adequacy. And that's basically defined by treaty. And the EU is going around to all these countries, and all these countries are passing their law and then requesting adequacy rulings from the EU. And of course, because their laws are almost identical to GDPR, they're getting them. And of course, the odd man out, of course, is the United States. There's also something here which does exist in the GDPR, but it's sort of funky. All the other countries are saying, okay, you can transfer if your data subject consents to the transfer. That does exist in the GDPR, but I'm not sure if it's frowned upon. They basically said this is sort of a one-off deal. But all the other countries have adopted it. So I think that will eventually wind up. So if you can, one of the exceptions is a good one to get consent. So if you want to transfer information around the world from different data subjects in all these countries, it's probably not a bad idea. In addition to, you have to get their consent for a number of things, just put that into the list. Okay, the problem with transfers is that the GDPR. Let's talk a little bit about fines. The GDPR got everybody's attention because for violation of principals' rights and transfers, they can say, okay, we get 4% of your gross global revenues, or 20 million euros, whatever. Anyway, the reality of this is that large as these fines are, they are in some ways chicken feed. Because, for example, there was a violation. Google just had a little problem, and they said, okay, we have 465 developers, and they were allowed to see personal information of something like 500,000 people who use Google+. Now, the question is that Google has decided, well, that wasn't a problem. We didn't have to report that. You know, we decided that that was a bug. It wasn't a breach. It was a bug. Anyway, the problem with Google is Google doesn't get to decide these things. I know it's going to be a surprise to Google's top management, but Google is not God. Google is not it does not have the power to legislate laws. Google is a company that's owned by a bunch of shareholders that can get fined like anybody else. So the problem is that these companies probably will get fined, but the fines could come from so many other different sources. For example, by Yahoo, probably Equifax. Let's see, what was the other one? There was, will all get fined, not for violation of security or not for violation of cybersecurity laws or privacy laws. They'll get fined for failing to provide investors with information about a material fact. Now, Google knew about this. This may have an impact on their share price. So they're not going to get fined by the GDPR or anybody in Europe. They're going to get fined by the good old SEC. So the SEC is going to come in there and say, Google, you knew about this and did you disclose it? Oh, no, it's just a bug. We didn't think that was important. Well, I think there's a whole lot of shareholders who might think it's important. Bingo, there's a $50 million fine from the SEC. As soon as that happens, this is an intentional failure to disclose. That means that the right of private action, which I'll get to, pops up. And so now all these other people who own Google stock, and that's about everybody, has the right to sue Google. So the numbers can rise precipitously, and it may not have anything to do with your compliance with any of these laws or the GDPR or anything else. Now, if Google had just said, well, you know, we have this problem, we're telling you about it, nothing would have happened. You know, if they complied, it has to do with complying with Article 35, 33, 30, oh no, it's 33, 34 of the GDPR, or the 50 state notice laws. If you did that, you would probably be in good shape. Did Google do that? Oh no. In its infinite wisdom, it decided, oh no, that's just a bug. Well, Google, I'm sorry, that's really not up to you. But so they didn't do it. That's another perfect example of how, you know, all these rules are coming together. Not in the way that anybody in the United States either intended or wanted. because we wanted, to basically be to go backwards. We wanted reactionary legislation, not foreseeing legislation. Well, unfortunately, the world, or fortunately, the world does not agree with us. So what has happened is, whether we like it or not, all these, the rule of law has sort of rolled on. It's a lovely little course. Now, one thing about laws is law obviously changes, after 40 years. I can sort of look back and see how the law changes with technology. The difference is that it usually takes a little more time before these things make their way through. So this slide, the point of this slide is to sort of show some of the cross sections. One of the big ones here is, remember, the GDPR is a privacy and cybersecurity. Like the NYDFS is sort of strictly a cybersecurity program. Now, the cybersecurity programs have rolled on, and they are now part of a whole lot of other things. Like, let's look at state breach laws. Well, the problem with state breach laws is there's so many different types. All 50 states have state breach laws. If you have a breach, or in Google's case, a bug, then you have to notify somebody. But some of the state breach laws also, I think about 9 of them, are cybersecurity laws, like Massachusetts. It says, yes, you have to notify, but also we require you to have a program for cybersecurity. So, or we can fine you. Now, the problem is also some of the state breach laws. It depends on how these next questions, how these things are enforced. The GDPR has, a whole bunch of methods to enforce these things. You can have the regulators fine you, or in cybersecurity world, that means all the regulators are going to fine you. Just don't think about, we're worried about us, the supervisory authorities and the GDPR. Oh no, if you're a public company, or even if you're not, you can get fined by the SEC. And remember, there are also 50 blue sky securities regulators throughout the United States. They can also fine you. So these things are not, they don't exist in the parallel universes. They are all part of what in my books, I would call your regulatory infrastructure, your legal infrastructure. Now, that will vary. There are some countries, obviously, that have more incentive to utilize these laws, and less, and others have less. My feeling of the GDPR will have very high incentive to enforce. Google was simply lucky because the bug, quote unquote, happened before the GDPR went into effect. So their maximum fine for this is 500,000 euros, but that doesn't, that doesn't get them out of the soup, because they have a whole lot of other ones. For example, let's start with Sarbanes-Oxley. The Sarbanes-Oxley, there's only one line in the entire interminable regulation that says your information systems have to work properly. That's all it is. Now, the CPAs have defined that as having some sort of cybersecurity system. So that has ended up in an entire cottage industry. But it does intersect that. Again, Sarbanes-Oxley is a cybersecurity law. It does not have anything to do with privacy. The SEC has both. They have SEC Rule SP, which is specifically a privacy law, and that does require privacy laws. But the SEC also requires that you disclose material information, and there are also SEC rules for cybersecurity. So the point is, to get back to, does your company have to comply with the GDPR? Well, maybe not. Your company does not have to comply with the GDPR, but somewhere, somewhere that you are doing will require compliance with something or other. The great thing about the GDPR is that it's so expansive that it does have a global sort of roadmap to allow you to comply with all these other things. There are also a number of really wonderful aspects to all this. One is that cybersecurity is getting away from the, your sort of standard checklist, check the box, let's go down through NIST, 853 and see what we got. and or COVID-5, something like that. We're getting to very specific risk assessments. Risk assessments, I mean, I said start off with inventory. You know, what stuff do I have? What data do I have? Where does it go? What do I do with it? And then now we move on to, okay, well, what risks do I have? I mean, with my clients, they come in all, you know, shapes and sizes, obviously. I mean, some don't have any risks. They have like, their information is B2B. They've got Gerhard Schroeder, their main contact for their supplier in Mannheim. And all they've got is Gerhard's telephone number and his email address, and they don't know anything else about Gerhard. But that's, you know, that is personally identifiable information. Is it risky information? No, it's not. Then I also have other clients that take pictures of operations. Does this hit all the whistles and bells? You betcha. So they have, obviously, that information is much higher risk than other information and will require different types of cybersecurity. Will have different types of privacy issues. Do all these people, that information be transferred anywhere? All of these questions come into the questions of risk assessment. What does your company do? All right, the other point, the governance model here in there. The governance model, what is governance? Well, the governance comes from a very ancient concept in the law called agency. And the point of agency is also in game theory. Agency problems exist because it's the agent's best move. Like a manager of a corporation, their best move is to give themselves enormous stock options, even though that might be bad for the shareholders, the real owner. All right, so you have to come up with methods of making sure that agents like management or employees or something like that are actually doing their jobs. So you have to make sure that you check on that. And that's a problem. That's a problem with American cybersecurity frameworks like NIST, CSF, is that there's no audit. There's the big point about like the certification, and remember, there's only one framework you can certify to, and that's ISO 27000. And the reason why that's important is because that's how you deal with the agency problem, is you audit and you check, make sure people are doing what they do. I'll give you a wonderful example of an audit issue, and that is our old friends Equifax. Most of you will know that the Equifax announced a patch to its Apache announced a patch to its popular Struts API, and on Monday and by Wednesday there was an attack. And you know, depending on who you believe, that's when the server was compromised. Now, what happened with Equifax is they thought they patched it all the servers, but guess what? They missed one because they didn't have a good asset inventory. So they couldn't scan their system faster than the hackers did. So the hackers were able to get into that. So in other words, if they had audited this type of thing and had been consistent with that, they would have found out, hey, why aren't we seeing that server? And they, you know, what information is on that server, and they might have been able to patch it. Maybe not, but at least they would have known what it is. And that's the problem with cybersecurity, is you got to check to make sure all this stuff is basically working correctly. And that's what the certification business is all about. In terms of the GDPR, Article 42 says that certifications, we encourage certifications, and you set them up. The thing about the ISO, the reason why that's sort of the default GDPR standard is because they already have this international infrastructures of auditing bodies which can come in and check to make sure everybody everywhere is doing everything right and everything in the same way. All right. Okay, this is the difference between the state laws. Now, state laws are all over the place. Don't worry about the penalties. Timing requirements varies wildly. It could be 30 days, it can be 72 hours. The main difference between the thing is between the state laws, or some of them are the penalty provisions. It's not the amount of the penalty provisions, it's what's called the right of private action. A right of private action basically allows a private plaintiff to step into the shoes of the regulator. So most states, I think like 3/4 of them, don't allow that. The only people who can fine the companies probably very limited amounts, are the regulators themselves, the Attorney General. The Attorney General has the right, at their discretion, can go in and check or fine or investigate the companies. If you have a right of private action, if the Attorney General does nothing, anybody affected by the hack or the breach or whatever, the notification, if notification wasn't timely, all these people can step in and say, look, we want our money. Now, the penalties, for example, we were talking about the penalties under the GDPR. Well, Uber just got fined by all 50 states, 148 million. Now, that's even before the private right of actions come in. So you're talking about the GDPR having major fines. Well, 148 million is not chump change. Plus, that's just what they give to these states' attorney general. Remember, a lot of these states have private rights of action. So a lot of these other people can move in. So there's timing requirements, definitions of personal information. What's that? Some of these, besides rights of private action, a lot of these statutes, some of them have privacy regulations, like California. Others of them regulate different types of things. And then some of them, about 9 of them, as I said before, have cybersecurity restrictions. So there's all different types of things. And these all have to do with how you regulate your cybersecurity. Now, okay, let's say you've got the best cybersecurity in the world. Does that help you? Well, no, because the reality is that somebody somewhere is going to say, well, prove it. So how are you going to prove it? Well, the only way to prove it is have documentation. I have a lovely little quote, and I always ask my delegates, where is it from? And the quote is that unless you document, you're not quite sure whether or not you actually did something, or whether or not it's just common practice or tradition with the company. And I ask people, what regulator said that? And somebody in Europe or something. No, it's Singapore. Singapore has had a privacy statute for the last 8 years, and they enforce it. This was an enforcement action against a major international corporation. No, it was a moving company and a hairdresser. So the question is, well, how do you do these things? And well, the best way to prove that you're actually doing these things is to have documentation. That becomes exceptionally important. So that's one of the things. Documentation, for example, is mentioned 22 times in the GDPR. So in order to prove that you actually do have a robust cybersecurity, you can't just say, oh yeah, well, what we have is we have the documents to show that we're actually configuring this stuff properly. I mean, like Equifax, that's another one. They had an appliance. This was a data loss prevention appliance, I believe. And they were saying, well, it's not showing any data exfiltration, everything would be fine. Well, they never audited it, so they never found out that it was misconfigured. When they configured it correctly, it went wild. It says that you're losing money, you're losing information all over the place. You just didn't configure this properly because they didn't really have a good system. So these are all sorts of different overlaps that have to do with these things. In other words, there's only a certain number of ways you can write a cybersecurity and privacy law. There's certain types of things that will be included in all of them. It just depends on where you are, what information. That should go also into your inventory. You should need, that's in the ISO world, we call that context. You have to know why you're doing something, what laws you're subject to. Okay, now global compliance. Yeah, look, this is the list. This is an incomplete list. This list is changing constantly. So, I'm behind. Let's see, I don't have Vietnam on this. I don't have Malaysia. I know they've got laws, and there are a whole bunch of other ones that do. So unless, you never leave Kansas, somewhere somebody is going to want to see what your cybersecurity and what your privacy program is like. So it's not just one or two of these other laws. Okay, now for a word from our sponsor. This is the EU GDPR. We sell a number of different types of things. One of we have all sorts of different products. It goes from on face-to-face training, which for me is always fun because I always get CISSPs, and it turns into a master's seminar, or there is online training, or we even have automated trainings now, all sorts of books and stuff and cyber awareness, all sorts of wonderful, great programs to help with you with your cybersecurity project on an international basis. Basically, because we are a global firm now, that we are concerned not only with the U.S. products, the GDPR, but also, I mean, if you look at the beginning of this seminar, everything has changed so rapidly. In some ways, we're catching up, because this has become the de facto global standard. And I'm sure something will happen in the United States in regard to privacy law probably very soon. Okay, now we're hopefully getting to the good part about this. Let's see if I click the button here. If any of you want to type chat messages and have any questions that relate to whatever I have said, or you have other questions that relate to cybersecurity or privacy or breach notification laws that you may want to know about, please type them in the chat window. And as you guys are thinking about whether or not you have any questions, I will tell you another issue. I mean, for example, to tell you why the fines are not really important, let's talk about the global shipping giant Maersk, M-A-E-R-S-K. It's a Danish company, and it controls the global. Canada is recognized as adequate, has been, along with New Zealand, Uruguay, Argentina, the Jersey Islands, and I will not. If I lump that into North America, I duly apologize. The problem with Canada is right now under the New Deal, there is some question about that transfer of information under the new treaty. Now that has to be passed by the U.S. Congress and the Parliament of Canada. And the privacy commissioners in Canada, I'm not sure. I believe there's one in Ottawa and there's one in each of the provinces. May have something to say about the provision. So we'll see how that acts out. I think that the Canadians will maintain that they don't want to do that because they don't want to mess up their trade with Europe. So I don't think that will survive the final pass, but we'll see how that goes. Right now, Canada is adequate and has been because they have a very strong PIPETA is actually wonderful, and they are the origin of the Article 26 for GDPR, which is the privacy by design and default. So my apologies for that, but that again, that's. We're talking about an open thing. Anyway, I was talking about Maersk, and Maersk. What happened there was fairly simple. They had a office in Odessa, and one of the let's see, in one of your slides you showed EU residents. I think not just residents, but yes, that is true. It's not. By the way, that is true of a whole bunch of other laws. Remember, if I'm in France and I kill somebody, even if I'm American, I am subject to EU French law. So if I'm in France and I am in France, I get all the benefits of the GDPR. So it applies to me because I am located in France. It also has to do with other things like me. For example, I am a US citizen, but I work for a British company. The British company is, oddly enough, located in England, is located in the United Kingdom. The United Kingdom, at least until next April, is a member of the EU. It's one of the member states, and the GDPR applies to all companies located in the United Kingdom. And so as an employee of a UK company, I get, in regard to my employee information, I get all the rights of a EU citizen. Now, as to other countries, that's a hot button topic. Each of these other countries have very, very different ways of looking at that. The Taiwanese they obviously the Taiwanese are a little sensitive about relations with China, so they have drastic fines for manipulating information to find or for watching any Taiwanese citizen anywhere. Some countries will only look at their own citizens, and other countries will look at travelers in their country as to regarding their personal privacy issues there, and that will vary according to things. Anyway, any other questions, or I'll go back to my story. All right, go back to the story. The story is that Maersk, their accountant, they didn't have adequate protections against installation of software. So the accountant in Odessa plopped in a local software package. This local software package, unfortunately, had a backdoor that was created by the Russians. The Russians unleashed a cybersecurity attack against anybody using this particular application. The cybersecurity attack was based, unfortunately, on something that was created by the NSA. Anyway, the Russians didn't want to collect any money. They just wanted to destroy things. And unfortunately, Maersk did not have adequate segmentation. They did not have control over what type of apps that were installed on their equipment, and they probably didn't know what equipment they had all over the world. So this thing wiped out all their information. It took them like 2 hours to go through it and just destroyed them. The only reason they were able to get back online is because one of their offices in Ghana had a power outage before the attack took place. And so they did have a backup that they could actually use. But the total costs to Maersk are estimated at right now 300 million, but probably it's 10 billion worldwide. So the object of this, the thing about most of this is that you have to think of you have to think of this as the fines are not the only problem. The main problem is the loss of property loss of your brand. Let's see. Another question has to do with a local official don't have to be compliant if an EU resident who is touring the US. That's correct. No, you do not have to be compliant. If you market to the EU residents, for example, to students coming to study at the NYU, well, no, it depends if they are in the United States, they're subject to EU law. So if you market to NYU students who are non-resident and you're marketing to them, say in English, and they come into you for treatment, that's not necessary that you have to comply with the GDPR. However, you still, you still have to comply with. Let's see what else you got to comply with. Let me think. I'm not familiar if there's New York regulations. You still have to comply with HIPAA. So you're still under 45/164/300. That's the security rule, and you're under the privacy rules. So if you're a health center, you have HIPAA requirements. Now, the question is, for a lot of these global compliance, at least for me, since there are not a lot of people around like me, is to make sure that you can synchronize all of the requirements. So yes, let's see, you've got a student in the United States from Germany, and you want them to come into your health center. All right. And you haven't advertised in German, you have a German website, et cetera. So you're not subject to the GDPR, but you are still subject to HIPAA. And some of these requirements I'm working through right now to harmonize them. Some of these requirements are the same in both places. So the cybersecurity, for example, is very similar in all the regulations. So just because you get out of the GDPR you still get out of HIPAA. So you have to configure what your entire legal regulatory framework is, and that really depends on where you are and what you do and what information you have and how you manage it. And that's sometimes can be a very complicated question. That's where data mapping comes in, which is a wonderful, it's an important thing for HIPAA. It's really important on the GDPR because you want to see, you can only process information if you have a lawful basis. And certain countries have adopted that, many have not. Lawful basis is usually based on consent, but quite often it's based on European six ways. So you have to have a lawful basis. So you have to, I have this bit of information. Why do I have it? So you have a data map that tells you how to do that. With HIPAA, the problem is that it's affiliated, affiliated businesses. So you've got affiliated businesses that you have to worry about with HIPAA. So do you exchange information with these affiliated businesses and what? So, and that depends, and then there's different scopes to these things. So privacy extends beyond, like privacy would extend into the cloud. So you have information, private information in the cloud, that's still under your control, but the security of that information might be controlled by the cloud provider. And the other problem with the, again, in like HIPAA is then there are intersections with other healthcare issues like the Stark rules and then the anti-fraud rules. So does this affect your foreign students? Maybe, maybe not. But it's all these things are very complicated. What I'm trying to do, and what I hope the ITG is going to try to do, is come up with a methodology for sort of one-size-fits-all compliance with variations. So if it's not, my point is, again, it's not just about some sort of whack job European law, because these things are so universal these days that almost whatever you do is going to, come back and require some sort of regulation. Okay. So, are there any other any other more questions that you have? Okay, I'm not going anywhere. So, if any, I work for ITG, and you can contact ITG at various points in time. I think that the slides are available, and you can get most of this information or more information on our website, or contact somebody. We have an office in New York now, or you can contact them. Anyway, unless there are more information, more questions, that's all I have right now. It won't be for long. So I will sign off, and I want to thank all of you for coming to this, and thank you very much for, wait a minute, thank you very much for your questions. Okay. Okay, the slides are available and will be sent to all with a audio recording. Well, that's a scary thought. Anyway, so I want to thank you all for coming, and please feel free, if you didn't get enough here, I will probably be talking again in the future. Anyway, thank you, and I'm signing off right now.